Part 4 of the Finance Bill lays out plans to grant HMRC preferential status in insolvency procedures from December this year, and measures to make directors personally liable for a company's tax liabilities where HMRC considers avoidance of evasion is taking place or for the evidence of phoenixism and tax abuse via insolvency. Madam Deputy Speaker, I very much want to see companies and their directors take their responsibilities seriously and to avoid phoenixism wherever we can. But I'm not alone in questioning whether this is the correct approach. R3, the Association of Business Recovery Professionals, wrote to the Chancellor last September saying, while extra money for HMRC in insolvency procedures may appear positive, it means less will be going back to trade creditors, pension schemes and consumers. This will hurt the economy in the long run. Poor returns from insolvency procedures can jeopardise the health of other businesses, can make creditors more likely to vote down rescue proposals and can trigger further insolvencies. The government's policy increases the chances of this happening. Coronavirus has brought this issue into sharp focus. UK Finance estimates that this policy could hit lending by at least £1 billion per annum. Furthermore, if HMRC gobbles up the largest amount first, there will be very little left for unsecured creditors such as SMEs. To give some examples, contractors and clients of a building company, food suppliers or parents who paid up front to a nursery that has gone bust. Why should creditors, real people in the real economy, lose out in much needed payouts rather than the vague notion of value to a taxpayer? The City of London Law Society has also highlighted in a letter in September last year that this proposal erodes depositor protections and would put the UK at a competitive disadvantage. So I urge the Chancellor and the Financial Secretary to the Treasury to give further thought to this measure.
These amendments seek to limit the extent of HMRC's status as a preferential creditor in insolvencies by preventing the policy being applied retrospectively and by limiting that preference to only those taxes which came due in the 12 months before the relevant date as given in the bill, which is the 1st of December 2020. In the context that we are in just now, Ms McDonagh, it's particularly important with firms increasingly running the risk of insolvency. It really is quite unfair to give HMRC a queue jump to recoup lost funds when other businesses and individuals may be well out of pocket in the real economy. These plans to grant HMRC preferential status in insolvency procedures from December this year and measures to make directors personally liable for a company's tax liabilities where HMRC considers the avoidance or evasion is taking place or where there is evidence of phoenixism, the tax abuse using company insolvencies. And I understand that the R3, the Insolvency and Restructuring Trade Body, are also very concerned about the prospects of these policies. They feel very strongly that this would damage business lending and impede business rescue to bring this in. UK Finance have suggested that this measure could hit the lending to small firms by over £1 billion. They set out, it's been set out at the previous stage when I made representations in the Chamber during the Finance Bill that this policy is incredibly problematic. On the issue of phoenixism, R3 have suggested that this could lead to blameless shareholders, lenders and businesses and rescue professionals being made liable for tax avoidance activities of rogue directors. So I would like to know from the Ministers what they intend to do to protect those who are innocent in this system from becoming liable under their proposals. And as well as having the detrimental impact on business and economic growth, restricted lending will make it harder to rescue businesses, increasing the knock-on effect of the insolvency on one business, on other businesses and individuals further down the line. Business investment, returns to creditors and confidence in the UK's corporate framework all stand to be damaged as a result, and I think the Ministers really need to give us a bit more detail on why they feel this is necessary. And while the tax abuse using company insolvencies measure can be mitigated through accurate legislative drafting and detailed guidance from HMRC, we feel very strongly that the policy to grant HMRC the preferential creditor status should be withdrawn in its entirety. And its introduction could well prove a hammer blow to business rescue and lending across the UK at exactly the same time when the government is seeking to level up the economy and support businesses as they try and make their way through these difficult days. And we all know, Ms McDonagh, of businesses in our own constituencies who are really struggling, who may not make it further than a couple of months ahead. And knowing that this is happening could have a detrimental effect, both on those who are supporting those businesses and on lenders as well into debt. So I think it is very important that the government looks at this very, very carefully, takes on board the concerns of R3 who have raised very substantial concerns about this policy being proposed, hence why we have the number of amendments that we have to this. And I would be very grateful if the ministerial team could tell us a bit more about exactly why this is required and why this change has been brought about. I highlight again, as I did at committee stage, the concerns raised by the Association of Business Recovery Professionals, R3, about the plans to grant preferential status to HMRC in insolvency procedures from December this year, covered by our amendments 9 to 15. They and UK Finance are concerned that this will undermine business lending and make it harder to rescue businesses out of administration. And we have seen many companies in recent weeks, many of them across the UK, struggling and going into administration. So the Treasury should consider carefully whether their plans will help businesses or hasten their demise.
Finally, I'd like to make a plea on behalf of those companies whose ability to borrow will be blighted to the tune of over £1 billion, possibly far more, by proposed changes to the government's Crown preference policy. Floating charge creditors and unsecured creditors, like pension schemes, would be leapfrogged by HMRC in any subsequent insolvency proceedings. Who's going to lend when they could lose everything if the company that they're lending to goes bust? This will seriously hamper the recovery, especially for small businesses. The insolvency and restructuring profession have been clear that the policy will make it harder to rescue businesses out of administration, and it will reduce the likelihood of successful CVAs. This measure should at least be paused until the full economic impact of COVID-19 is known. I urge the government, please don't help with one hand and take away with the other.
There are more points, but time is short. And as a veteran of the proceedings on the Corporate Governance and Insolvency Act, I want to say now that I share, as I did then, the concerns expressed by my noble friend Lady Burt about the new preferential status for HMRC in insolvency, making it even wider in scope than before the Enterprise Act in 2002. And the arguments don't wash about it relating to tax paid by employees and held by the company, given that the company does not apply that logic to pension schemes in the hierarchy.
My Lords, I wish that the Treasury were more joined up. On the one hand, the Chancellor has provided massive support to businesses to help them through the pandemic and to enable economic recovery, and this has been terrific. But at the same time, the Treasury are legislating to make business rescue and business lending much more difficult. As the Noble Baroness Lady Burt of Solihull noted, this finance bill reinstates Crown preference in insolvency for tax debts. As she said, R3, the representative body for insolvency and turnaround professionals, has called it a potential £1 billion blow, and I think that may well be an understatement. The Crown preference proposals were heavily criticised before the COVID-19 pandemic hit us, and in the current context, Clause 98 could well prove disastrous if business rescues are hampered or if indebted businesses cannot access further debt.
I think, as others have urged, that the noble lady Baroness Burt, my noble friend Baroness Noakes, that the return of Crown preference, even in a diluted form, is unwelcome, particularly in the present scenario. It will have the effect of prejudicing businesses as creditors at a very, very difficult time, effectively enabling those businesses to be queue-jumped, as it were, by the Crown. This is not appropriate in my view.
The third travesty, and it's in this finance bill, is the restoration of Crown preference, putting HMRC ahead of the queue in collecting money from bankrupt companies. At a time of national emergency, a measure that will hit small creditors and suppliers badly, as we heard from Baronesses Burton Bowles and Lord Byrne, is completely unacceptable.
And that leads directly into my next point, which is the bill reintroduces the concept of making the HMRC a preferential creditor. And I am very concerned that all the good work that my Right Honourable Friend the Secretary of State is doing in this bill could be unwound by its doing that. It could have a really negative impact on business rescuing and lending across the UK. and don't take my word for it, I looked at what the industry insolvency practitioners have said, R3, and they're directly making this point. And it goes against a policy that has been in place for some 18 years now, which has encouraged lending to small businesses.
It's a very, very important point, and I think the legislation is covered in the Finance Bill, Clause 95 of the Finance Bill, that's making HMRC a preferred creditor once again. The real concerns about it is not just the fact that lenders will be less willing to lend on that basis, which is a real concern because you go above lenders with a floating charge, but also that HMRC may be less willing to negotiate, to show forbearance to businesses who are seeking to have some protection and time to get through these problems.
Well, I thank my honourable friend for his intervention. The House will be pleased to know that he won't need to listen to the next couple of minutes of my speech on that basis, on the basis that he has just made exactly the point I wanted to make about floating charge, particularly. Those are the normal financiers to these sorts of businesses, and if they find themselves displaced in the ranking of credit, of priority, then they are less likely to lend, and that will have an impact. And this was introduced in 2002, it's seen an extraordinary expansion of lending via those floating charge providers, and it would seem odd that we are in one place trying to do one thing in one piece of government legislation and potentially undermining, or rather I suspect, undermining the impact of this very welcome bill in another. So I hope that the Minister will, with his formidable powers of persuasion, speak to the Treasury about this matter.
But as I've alluded to, the problems for this bill lie in three other areas. Another piece of legislation, the Finance Bill, which I believe actually undermines, I don't think it risks it, I think it actually undermines these provisions and sets the conditions that could push companies to the brink. Plans, as have been mentioned, to grant HMRC preferential status in the insolvency procedures, and measures to make directors personally liable for companies' tax liabilities. Together, these represent a significant challenge to businesses across the nations of the UK over trying to access working capital finance. So while noting it's difficult to accurately model the policy's impact on business lending, UK Finance estimate that the policy could hit lending by well over £1 billion per annum, and possibly, because the modelling is difficult, possibly much more than that. As well as having a detrimental impact on business and economic growth, restricted lending will make it harder to rescue businesses, increasing the knock-on effect of insolvency on other businesses and people. Business investment, returns to creditors and confidence in the UK corporate framework all stand to be damaged as a result. And while the tax abuse using company insolvencies measure can be mitigated through accurate legislative drafting and detailed guidance from HMRC, the policy to grant HMRC preferential creditor status should be withdrawn entirely, as its introduction may prove a hammer blow to businesses looking to rescue and to lending at exactly the time that the government professes that it is seeking to level up and support businesses as they adapt to the impact of COVID-19.
Any other creditor. And this is where the contribution from my honourable friend, the member for Wimbledon, I think was interesting, where he highlighted the part of the bill where the HMRC becomes a preferred creditor. Well, those of us who've had to deal with the HMRC as a creditor in the past wouldn't mark them down as one of the most amenable of creditors when it comes to their own interests. And that's putting it lightly. In fact, the HMRC...
But the last thing we want is for these issues to be dealt with in silos. The legislation in the 2020 Finance Act ensuring that HMRC is a secured creditor in insolvency proceedings is surely a classic example of this, potentially running a coach and horses through the bill. Many issues need a cross-government approach, which is appropriate, my lords. Our insolvency framework touches almost every part of the economy and helps to create the confidence and public trust which underpin trading, lending, and investment.
I also believe strongly that the government should drop its provisions in the finance bill, which would give HMRC as a creditor primacy over other creditors. If that is not dropped, small suppliers will be even harder hit in a ripple effect, which our economy cannot afford and which in the long run damages the national tax take even more. But I want to ask the government to use this bill to give greater protection to small creditors, but typically trade creditors in an insolvency.
And, as has been already suggested, to the position of HMRC as a preferential creditor, given the immense harm that situation may create, particularly for other creditors.
What am I concerned about, my lords? My worries include the changes to the creditor position at HMRC.
However, none of the provisions of this bill will help business in continuing to trade after the pandemic if Part 4 of the Finance Bill, which changes the order of preferential creditors on insolvency, comes into being. Small suppliers will not only find themselves at the bottom of the pecking order for payment, they'll find access to credit, particularly from floating charge lenders, in all probability cut off. Floating charge lenders who lend against a changing asset such as stock are very important, particularly to small businesses. They came into being after the rules on preferential creditors were changed to what they are today in 2002. So why change it back just when they are needed more than ever? And who would continue to lend if the chances of getting their money back in the event of insolvency was severely diminished? The government has not published a proper impact assessment or the data used to arrive at the anticipated revenue to the Treasury of £185 million. But UK Finance, the body that represents many of these floating charge lenders, estimates, while noting that it's difficult to accurately model the policy's impact on business lending, that the policy could hit lending by well over £1 billion per annum and possibly more. So how can this be a cost-effective measure for anyone? At the very least, can the policy be paused so that a proper impact assessment can be done? Or could a 12-month time gap on age debts eligible for preferential status be imposed? Would the Noble Lord the Minister consider an amendment ensuring HMRC's preferential claim does not outrank floating charges created before December 2020?
The Revenue and Customs as a preferential creditor could adversely affect the availability of funding, especially asset-backed lending, and have a major unintended impact on creditor arrangements, unless we can see some clear view of how the HMRC will operate. Indeed,
we've all had the briefing note from R3, which says that HMRC are now legally the preferential creditor. My lords, the government cannot have it always. They cannot compel a supplier to supply goods and then compel him to wait behind the HMRC for payment. That is very unfair. And if I were a supplier, then I would use the hardship excuse every time to cancel the contract if I'm going to be stuck behind the HMRC every time for payment. Thank you, my lords.
I'm concerned at the changes to priority status for certain creditors. In particular, the reintroduction of HMRC's priority status, matters raised by others, including my noble friends Baroness Burt and the noble Baroness Kramer. Parts of the 2019-21 Finance Bill undermines efforts to support businesses in the bill before us. The proposals make HMRC a secondary preferential creditor. Thus, clauses 95 and 96 of the Finance Bill should, in the light of the Insolvency Bill, be withdrawn. Reintroducing HMRC preference seems to be pulling in the opposite direction from taxpayer support being provided by the government at the current time to help businesses survive. This, my lords, impacts on pensioners, suppliers, customers, and lenders. I think trade creditors and floating charge creditors could be forgiven in thinking, what has HMRC ever done for me?
Stopped. And second, can I add my voice for the government to reconsider the finance bill provisions. Making HMRC a preferential creditor right now could be a hammer blow to businesses, rescue and lending across the UK.
Look at that. The other one is the repositioning of where HMRC comes in the list of creditors. And it seems to me the change that's suggested there will adversely affect floating charge creditors and unsecured creditors.
I share the concerns of many other noble lords, including my noble friends Baroness Neville Rolfe and Lord Lee of Hurley, about the reintroduction of HMRC's preferential creditor status on insolvency. Indeed, as the noble Lord Palmer alluded to, this seems inconsistent with spending so much public money to help firms through the current time, and the success of the emergency public funding could be undermined by the sudden leapfrogging of HMRC claims on corporate resources, even though I do recognise that corporation tax, employer NICs and others remain as unsecured debt.
My Lords, is the Minister able to address the creditor who is the elephant in the room? I refer to the preferential status to be given under the Finance Act to HMRC for VAT. I understand that the argument is that the company has collected this and needs to hand it over. But is there not a similarity to the supply of widgets essential to the business, who is destined to be below the salt in the list of creditors requested in the amendment? The Finance Act 2019-21, which we put aside and hardly mentioned during these debates, seeks to give preference to HMRC for VAT. This undermines the whole principle of this piece of legislation, which I believe is, as I think more or less Lord Hodgson said, we are all in it together. Well, if you give the banks preference, even unintentionally, or if you give HMRC preference in the Finance Act 2019-21, we're not all in it together. Some are more equal than others.
And finally, while the Secretary of State and the Minister should be working to champion these sectors, vital to so many, could he also take the practical step of supporting our SNP amendment to the Finance Bill to stop HMRC's planned vulture powers? Two policies in Part 4 of the bill could damage business lending even more. Preferential status represents a significant challenge to the UK's business community and access to working capital finance. Preventing tax avoidance, evasion and phoenixism is vital, of course, but this measure is not the way to do it. So will the Minister today indicate his support for that measure in the Finance Bill? Thank you, Mr Deputy Speaker.